6 at 9. Uh, did you do that case already?
Let me look and see what number is that on our docket, sir.
That's case number
First one.
25.
Okay. It was the first thing I called this morning, sir. We heard some motions to delay the March 4 contested hearing. I denied them. We are basically on track for a March 4 contested hearing.
Oh, okay. Thank you, sir.
Thank you.
Thank you.
Yeah.
Yeah, I just
Freya, are you ready to continue? You are ready. Okay, good. And Mr. McClure, are you ready?
I am.
Okay, sounds good. And Mr. Cogswell, let me know when we're back on the record. Thank you. Thank you. It is 12:34 p.m. on February 13th. We are continuing the docket for the Oil Conservation Division hearings. We are going to pick up with the Riley Permian cases that we paused earlier because the exhibits were not ready to be reviewed. I understand from Mr. McClure that he has reviewed the exhibits. Is that correct?
That is correct, Mr. Hearing Examiner.
Okay, so I'm going to call the three cases 250, 47, 48, and 49. Entries of appearance, please.
Yes, good afternoon, Mr. Hearing Examiner. Miguel Suazo with the Santa Fe Office of Bidding Wozniak, representing Riley Permian Operating.
Thank you.
And Dana Hardy on behalf of Spur Energy Partners.
Okay, thank you. And Ms. Hardy, did you object?
No, Spur did not object. We're just monitoring.
Monitoring. Okay. Are there any other entries of appearance, Mr. Suazo, that you know of?
No.
Okay, please proceed.
Yes, so Riley is requesting applications to approve 3 standard horizontal spacing units and pooling all uncommitted interests. The first case, 25047, is in the Yeso formation, underlying a 160-acre standard horizontal spacing unit composed of the north half of the south half of Section 33, Township 17 South, Range 27 East in Eddy County. And this proposed Yeso unit will be committed to the Eagle 33 FedCom 004H and the Eagle 33 FedCom 005H. In case number 25048, also in the Yeso formation, and also underlying a 160-acre horizontal spacing unit composed of the south half of the north half of Section 33, Township 17 South, Range 27 East, also in Eddy County. And this will include the Eagle 33 FedCom 007H and Eagle 33 FedCom 008H. And finally, in case number 25049, also in the Yeso formation, underlying 160-acre standard horizontal spacing unit composed of the north half of Section 33, Township 17 South, Range 27 East in Eddy County. This Yeso unit will be committed to the following wells: the Eagle 33 FedCom 010H and the Eagle 33 FedCom 011H. The exhibit packet that was filed on Thursday, February 6th and amended yesterday, February 12th, contains the checklist, the application, and the affidavits. Exhibit A is the compulsory pooling application checklist, which Mr. McClure requested some amendments to. Exhibit B is the application and proposed notice of hearing, which was filed on February 6th. And Exhibit C is the affidavit of Riley's land witness, Mr. Mark Smith. Mr. Smith has testified before the division, and his qualifications as an expert in petroleum land matters have been accepted by the division and made part of the record. Mr. Smith notes on Exhibit C that there are no overlapping horizontal spacing units in this formation. Exhibit C1 is a general location map. Exhibit C-2 contains the Form C-102s. C3 depicts the tracks in the spacing units and wells. C4 includes the ownership within the units and identifies the committed parties. C5 is a map depicting the non-standard horizontal spacing unit in relation to a standard unit and identifies the offset owners. C6 contains the well proposals. C7 contains the AFEs for each proposed well. And C8 provides a chronology of contacts summarizing attempts to obtain the participation of the pooled parties. Exhibit D is the affidavit of Riley's geology witness, Mr. Doug Standard. Mr. Standard has not previously testified before the division and
Okay,
requests.
Mr. Suazo, let's get him qualified.
Okay.
Mr. Standard, would you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, or nothing but the truth under penalty of perjury?
Yes, sir.
Okay, let's, what field of expertise do you seek to be qualified as an expert before this division?
Petroleum geologist.
Okay, perfect. Petroleum geologist. Okay. Tell me about your education that goes toward that field.
Yes, I received my bachelor's of geology at the Utah State University in 2006. I then followed that up with a PhD in geology at the University of Texas at El Paso at the end of 2010, or sorry, at the end of 2014, where I began shortly after my career at Marathon Oil as a development geologist, where I participated in the development and execution of a multitude of Middle Bakken and Three Forks wells for about 3 years before I started with the Oklahoma asset team, developing and executing the scoop and stack wells in the Woodford and Merrimack there. In 2021, I started at Riley, where I've since been helping with development of our shallow carbonates in the Permian here.
And what is your title at Riley?
Senior geologist.
Senior geologist. Okay, thank you, sir. You are qualified as an expert in petroleum geology before this division from here on in. Mr. Suazo, instead of going through the table of contents, I've read it. Let's offer up your exhibits into evidence in these 3 cases. Are there any objections?
No objection.
Not hearing any objections, your exhibits are admitted into evidence. Let's go to Mr. McClure. Do you have any questions, Mr. McClure, in these 3 cases?
Yes, I do, Mr. Hearing Examiner. I have questions for the landman, Mr. Smith.
Mr. Smith, I don't think I swore you in yet. Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but truth?
Yes, sir.
Okay, thank you. Please state and spell your name for the record.
My name is Mark, M-A-R-K, Smith, S-M-I-T-H.
Thank you. And have you previously been qualified as an expert?
Yes, I have.
In which field?
Petroleum landman.
Landman. And that's before this division?
Yes, sir.
Okay, Mr. McClure, he's all yours.
Thank you, Mr. Hearing Examiner. Mr. Smith, in your statement, it says that the list of pooled persons is included in Exhibit C4. Is that correct?
That is correct.
Okay, Mr. Zazel, can you share your screen, please?
Mr. Suazo.
Suazo, I apologize, sir. Mr.
That's
Suazo.
okay. I'm just repeating.
I'm actually not connected to the internet because I had to just move or.
Ms. Hardy, are you connected? Would you be able to share? Mr. McClure, we're working on it.
Hey, thank you, sir.
Is there a page number that Ms. Hardy should pull up?
The beginning of Exhibit C4 begins on page 20
20.
of
Thank you.
58. Yep.
Thank you. Ms. Hardy, it's page 20.
Yes, it's the last one.
Mr. Suazo, is your amended exhibit, does it have a cover letter?
It does.
Okay.
Page 20.
Yes, please. Perfect. Thank you.
Yep. Thank you, Ms. Hardy. Mr. Smith, I was looking to his exhibit and maybe I'm misinterpreting something or missing something, but can you direct me, I guess, to where we have the pooled persons listed out in this exhibit?
Yeah, I can explain what you're looking at right now. So we are looking at a before payout interest as well as an after payout table. The reason why we described both was because of an older term assignment that technically all the parties have agreed that has terminated. But per that term assignment, there were some reversionary interests, which you will see on the table that says APO at the bottom. We're listing those parties really, so let me back up. The parties we're pooling are Spur, SEP Permian, and Chaunas. Chaunas actually signed the joint operating agreement last week, so they are actually a committed interest now. So we're only pooling at this point Spur. However, because of record title, the old term assignment has not been terminated of record, and there hasn't been like a reassignment of interest to XTO. And I think I said only Spur. We're pooling Spur and XTO as well. We are, out of an abundance of caution, describing the parties that were subject to that old term assignment and the reversionary interest. But like I said before, parties have confirmed, because there was a well that was holding or continuing that assignment, that term assignment, which is no longer producing. Everyone feels that that term assignment has terminated, and that the parties that do own the operating rights would be Riley, formerly known as Pecos, because they were our predecessor, Spur, and XTO. And as I previously stated, Shauna's signed the joint operating agreement last week.
Okay, so Mr. Smith, so then the persons being pooled would be like looking at this blue table that the blue header table that we have on the screen there. It would be the third one on that list, and that is who Riley is seeking to pool. Is that correct?
That is correct. It'd be the folks in the blue table. That's correct.
Now, am I correct that that is not indicated anywhere within the exhibit?
I'm not sure I'm following.
Well, Riley came before the division asking us to use a state's authority to force pool somebody into this pooling agreement, but I'm not seeing where it actually tells us who you're asking us to force pool. You have a summary of interest, which is required, yes, but I'm not seeing where it's written anywhere here what you're asking. And am I wrong on that, or is it included anywhere in your exhibit packet where it states Spur is being force pulled or asked to be force pulled?
I guess I'm confused. Yeah, because that was the purpose of this C4, was to describe the parties we are pooling.
Well, the purpose of your I guess I can't speak to the purpose of your exhibit, but typically the the applicants will provide a summary of all the interests. And then in addition to that, they will tell us. Yes, absolutely, sir. I agree with you there. But in addition to that, they need to tell us which parties are not committed and which parties are going to be force pulled or requested to be force pulled. Do you understand what I'm asking for, I guess?
I do. I understand. Yes. And
okay.
Yeah.
Okay. Now you kind of touched upon my next question in your earlier answer, but I'll ask it again just for additional clarity here. Which interests in this list does Riley own, I guess?
We own the interest of Pecos Oil and Gas, LLC.
Okay, thank you, sir. And is there any statement or mention within your exhibit describing the relationship between Riley and Pecos Oil and Gas LLC?
I'm not sure if it specifically does, but I wanted to list what was a record title, because there's a lot of BLM assignments that take over a year to be approved. So Pecos still shows up in title in a lot of the leases that we purchased from Pecos over a year and a half ago.
Okay, I guess if I ask for some sort of description in an amended statement from yourself, just describing the relationship between Pecos and Riley, do you understand what I'm asking for?
Yes.
Okay. And do you also understand what I'm asking for in regards to a list of persons that Riley is asking to force pull?
Yes.
Thank you, Mr. Smith. Mr. Hearing Examiner, I have no further questions, but I would request that Mr. Sazel provide these documents that I referenced to Mr. Smith.
Okay, thank you, Mr. McClure. Mr. Suazo, do you understand what Mr. McClure needs?
Yes, we do.
Okay, good. Can you just repeat it?
Yeah, so I understand we need to indicate based upon the chart which interest is actually being pooled. And we also need to explain how it is that Pecos Oil and Gas is the predecessor to Riley.
That's perfect. Mr. McClure, does that sum it up?
Yes, it does, Mr. Hearing Examiner.
Okay, Mr. Suazo, so it sounds to me like, Mr. McClure, you finished your questions. You have no other questions, right? Okay. And once we get this information, we can take these cases under advisement?
That is correct, Mr. Hearing
Okay,
Examiner.
perfect. Mr. Suazo, how long do you need?
We should be able to get that in by the end of the day, if not tomorrow.
How about, we'll say tomorrow.
Okay.
Okay, so I'm going to give you a deadline of 2/14/25 at 5 p.m.
Perfect.
Once we get that, so that'll be your second amended packet
Yes.
with a new cover letter.
New cover letter, we'll include it all in
Perfect.
one.
Very good. Anything else on your cases, Ms. Suazo?
No, Mr. Examiner.
All right. I think that concludes it. Thank you, Ms. Hardy. Congratulations again. Thank you, Mr. Suazo. And please file that motion to dismiss that other case and then get it refiled so we can fast track it for you.
Thank you so much.
You're welcome. Ms. Vance, let us recall case number what?
It is, it's case number 25118.
118.
Yes.
Let me get to it. 25. And that was your amendment case. And I had asked you about the.
The time frame of
That's
everything.
correct.
So
The order.
yes, and our landman is on the line. He and I have spoken. I can walk you through it. So if you.
Well, I
if
have evidence in front of me that says one thing. So are you going to are we going to elicit some new evidence?
I guess I would have to put something together, but I can come, or he can join us and he can
Is he with
confirm.
us?
Mr. Crawford should still be online. I know he was listening in and he said he was good. Yes, he's right there.
Okay, good. Let's get Mr. Crawford back. Mr. Crawford, I remind you that you're still under oath. Okay.
Yes.
All right. So Ms. Vance, do you have any follow-up to the question that I asked Mr. Crawford?
Yes.
Go right ahead.
So these wells that were under.
You're not testifying. You're just asking questions to Mr. Crawford.
Okay, fair enough. Sorry. Mr. Crawford, when were are you familiar with order R22769 in the original case?
Yes,
Okay. And are the wells that were originally under the case SND 1423 FedCom 429H, 430H, 431H, and 432H?
yes, that is correct.
And when were those wells drilled?
Those wells spud on February 14th of 2024.
And when was the order, when were you required under the order to drill those wells?
That would have been July of 2024.
Okay, so they were drilled in accordance with the order.
That is correct.
Okay, and those were required to be completed at what time? I guess let me were the wells under the order, the wells would have had to, they would need to be completed a year after they had been spud, correct?
Yes, that's my understanding.
And when did those wells start producing?
They started producing in November of 2024.
Okay, so those wells have been perfected under the order, correct?
That is correct.
Okay, let's continue with, now I have new evidence to proceed. So now, where are you in your presentation of I know we've completed 25119. So
Yes.
now we're dealing with 25118 only.
Yes.
And you're asking the division for what?
So we're asking to reopen and pool the entirety of the Bone Spring formation, add additional wells under the order, but this application is for purposes of pooling only overrides and record title. Chevron has voluntary agreement with all working interest owners.
Okay, perfect. Now, why don't you offer your exhibits into evidence? Let's short circuit this.
May I offer my exhibits into the record?
Are there any objections? Not hearing any, your exhibits are admitted into evidence. Let's turn to Mr. McClure. Mr. McClure, do you have any questions about this case 25118?
Yes, I do, Mr. Hearing Examiner,
Okay.
for Mr. Crawford, the landman.
Please proceed.
Mr. Crawford, the original case for R22769, that's case 23562. Are you familiar with that case?
Somewhat, yes.
Within that case, it references a depth severance at presumably the base of the first bone spring based on the order.
That
Is
is
that
correct.
okay? What is the status of that depth severance now?
The status is still the same. What we're looking to add the first bone spring to this force pulling order. The ownership is somewhat different, and that's shown in our exhibits. So the first bone spring has different ownership than the second bone spring. Well, from the base of the first bone spring to the base of the bone spring. To the top of the wolf camp.
I pardon Mr. Crawford. Can you say that last sentence one more time?
Yeah, the ownership is different in the first bone spring than it is from the base of the first bone spring to the top of the wolf camp.
Mr. Crawford, are you aware of whether that's included in any of your exhibits for the case before us today, case 25118?
Yes, that should be included in the exhibits. Pulling up the application now.
And Ms. Vance, are you able to share so Mr. Crawford can direct my attention there?
I'm pulling it up now. So, and I would say we didn't really provide much in the way of the depth severance because we do have voluntary agreement with the working interest owners that are impacted by the depth severance. So this is strictly pooling overrides in the record title.
Can you explain that? Just for my understanding, and maybe Mr. McClure's, he may already understand this anyway, but what do you mean when you say just overrides and title record only?
So the overriding royalty interest owners, so that's a different type of interest than a working interest. And so those particular interests are carved out of, whatever other instrument. And so, those interests, they're non-cost bearing, so they don't have a right to drill.
Mhm.
And so, in this particular case, we're just pooling those interests, and typically, and a lot of times operators will pool those interests if there's a question of the pooling clause in the instrument that carved out that interest. Sometimes it's hard to locate those parties, and based on the division's requirement of pooling the mineral interest, it includes working interest, overrides, and unleased mineral interest owners.
So in your application for these non-cost bearing interest owners, override interest owners, are you seeking to have them bear the costs or not bear the costs?
No, they are not bearing the cost.
Then why do you seek to pool them then?
So again, if there isn't a sufficient pooling clause in the instrument that conveyed that interest, or there's a question of whether or not there is sufficient pooling authority in the instrument that conveyed that interest, we come to the division and we pool that interest.
So you can allocate profits to them.
Based on,
Right.
yes, using the division,
Okay.
the state authority for force pooling.
Okay. And then what about these title?
Record title,
Yes.
typically that's related to, again, if you are unable to locate the party and you need to get a signature on a communitization agreement, both a federal or a state communitization agreement, an operator may come and do force pooling, because both the state land office and the BLM will accept a pooling order in lieu of a signature for the COM agreement.
Okay. So it's almost like a catch-all.
If you would like to define it that way, Mr. Hearing Examiner.
Thank you, Ms. Vance. Coy. Okay. So Mr. McClure, do you have what you need here to ask further questions?
I have what I need here to ask further questions, Mr. Hearing Examiner.
Please.
Mr. Crawford, I guess before you were kind of looking through your application packet to see, or excuse me, your exhibit packet to see where you have the death severance described. Based off what Ms. Vance said, do you still believe that it's described in the exhibit packet? And if so, can you direct us to where that is?
I am not seeing it in the exhibit packet. It looks like the ownership for the first Bone Springs missed the application packet.
Okay, when you say the ownership for the first Bone Springs missed the application packet, what do you mean by that?
The page that we were just on shows the ownership from the base of the first Bone Spring to the top of the wolf camp. The spreadsheet for the first Bone Spring alone does not appear to have made the application.
Okay, I understand what you're saying.
Okay.
Thank you, sir. I believe you kind of alluded to or maybe describe it. Can you describe again for me the difference between ownership between the Bone Spring 1 and rest of the Bone Spring?
Yes, there on the screen, you'll see the southeast quarter of section 14 is owned working interest by McLeod Holdings. And that is true from the base of the first Bone Spring to the top of the wolf camp. However, as far as the first Bone Spring goes, in the southeast quarter of section 14, McLeod Holdings owns an interest there, but so do Vladin, Tinian, and Blue Star as well in that southeast quarter of section 14 only. They are all parties to the JOA, but the ownership spreadsheet for the first Bone Spring alone is missing from the application packet.
Okay, is the difference in the death severance restricted to only the working interest owners then?
Yes, and in the southeast quarter. Well, let me double check that. Yes, in the southeast quarter of section 14, in the first Bone Springs only, McLeod Holdings has an overriding royalty interest. Vladin, Blue Star, and McLeod Holdings have the working interest along with Chevron.
Okay, is any of the persons that Chevron is asking to force pool, does any of those persons have a different interest between the Bone Spring 1 and the rest of the Bone Spring, overriding or otherwise?
Double checking right now. They appear to be the exact same, with the exception of Blue Star Oil and Gas.
And Blue Star Oil and Gas is one of the persons that Chevron's asking to force pool. Is that correct?
That is correct, for their overriding royalty interest.
Yes, I understand that. I guess I can go into the next question then. Is it correct that Blue Star Oil and Gas would receive a different revenue based upon whether the well is in Bone Spring 1 versus the rest of the Bone Spring?
Just double checking my numbers here. I'm sorry, I was on the wrong line in my Excel spreadsheet. Blue Star does have the exact same overriding royalty interest in all of the Bone Spring formation.
There, that makes it a little less grievous, I guess. Was any consideration done by Chevron for simply having two different compulsory pooling orders, one for the Bone Spring 1 and above, and the existing one for below the base of the Bone Spring 1?
Yes, that was looked into, and I believe the reason for trying to have it all in one is for commingling of oil and gas farther down the road. And Paula can correct me if I'm wrong on that.
Mr. Crawford, Paula is not a witness, so she can't correct testimony, which is evidence. So when we're finished with your testimony and Mr. McClure's questions, counsel can redirect to clarify anything you need to be clarified. But this is the part of the hearing where we accept evidence, sworn evidence. And
Okay.
So, Mr. McClure, please continue.
Thank you, Mr. Hearing Examiner. Yeah, to be honest, I wasn't actually waiting for Ms. Vance. I was thinking about whether I wanted more questions on this, but Mr. Hearing Examiner, I think I'm done with my questioning here, but I would request for some additional documents to be submitted.
Okay. Let me turn to Ms. Vance to redirect the witness. No.
I don't have any questions.
All right. So then are you ready for Mr. McClure's list of documents?
Sure.
Okay. Mr. McClure?
Yes, Ms. Vance, Exhibit D3, the cross section. I have on my notes that it does not include the API numbers for the wells. Can you please correct that and submit an amended exhibit packet?
Yes.
In addition to that, can we submit the ownership tables for the Bone Spring 1 and also include an additional description, either in a landman statement or some sort of supplemental that describes the depth severance?
Yes, I'm double checking because I thought that that's what I was looking to
Yeah,
see.
I
Okay.
believe
It's in the application, but it doesn't have the reference well. So understood.
Okay, Ms. Vance. Yeah, I was going to say what's in the application, I think describes the prior order
Mhm.
more so than it describes the current depth severance. But regardless, in addition to that, we'll need the compulsory pooling administrative checklist corrected to reference that depth severance as well. Do you understand what I'm asking for, Ms. Vance?
Yes, I gotcha.
Okay. And I guess, do you understand what the likelihood is of getting approval for this application and the steps that Chevron could elect to do in regards to submitting another compulsory pooling application to pool the Bone Spring 1 and above the depth severance?
Just to go back to the question that was asked and provide some clarification. So the reason why we did it this way is because we had an existing order and Chevron has voluntary agreement from all the working interest owners who are impacted by the depth severance. And I believe, as Mr. Crawford described, the parties that they're seeking to pool are overrides, and there's no difference for those parties in terms of an impact related to the depth severance or the record title. So it didn't seem necessary to have to do have an additional order related to the same acreage where they already have voluntary agreement where there's impact related to the depth severance. So I guess maybe I'm a little confused why we would need to have two separate orders for something that's completely uniform when we're talking about the interest that we're pooling.
Is there a reason for needing to force pull the overrides in this case?
Yes, as I discussed with the hearing examiner, I think that there was a question about, whether there was sufficient pooling authority in the instrument that conveyed those interests. And so we also needed to pool the record title for purposes of a communitization agreement. And that's why we came to hearing. And since we had the existing order, we felt it was administratively efficient to just be able to use that order, open it up, and pool the entirety of the Bone Spring regarding those interests that Chevron was seeking to pool.
Yeah, I understand, I guess, the reasoning behind why the law firms in general, out of an abundance of caution, typically, I would say, ask to compulsory pool the overrides. We've never, typically they don't come and give us the actual agreements regarding whether it has a pooling clause or does not. I guess what my question was more for Chevron's internal reasoning as to whether they believe that an order is even required here for their own review and whether they should potentially come back if this case gets denied.
Well, I think the reason why we're here is because that determination was previously made. And I'm not really understanding why this would be denied.
I don't know that this is productive conversation at this point. It seems like, Mr. McClure, you're trying to express something, and I think it's not being received in the way you think it would be. So why don't we skip this part, if you don't mind?
Yeah, understood, Mr. Hearing Examiner.
Thank you, Mr. McClure.
Yep, thank you. I think Ms. Vance has a full list of
Okay.
what we would need to cure this application.
I do. It's the D3, adding the API number. We will revise Mr. Crawford's land statement to include a description of the depth severance. And then I will update the compulsory pooling checklist to include a description of the depth severance. But again, we are pooling interests that are not impacted by the depth severance.
Ms. Vance, I think Mr. McClure also wanted a list wanted a table. Mr. McClure, why don't you put it in your own words?
The Bone Spring 1 interest that Mr. Crawford had reference to, that's not included in the application.
We'll include that as a part of his updated pooling exhibit.
Perfect. Thank you. Okay. How much time would you like?
I will, Mr. Crawford is on the line. I'm not sure how long it may take him, but perhaps maybe if we just have like a week from today.
Mr. Crawford, is that enough time for you?
That's plenty of time, yes.
Plenty of time. Okay. So why don't we say a week from today, which would be the 20th of February, close of business, 5 p.m.?
That sounds perfect.
Once we receive that, we'll take this case under advisement.
Thank you.
And I realize you haven't had lunch. Thanks for hanging in there. We're off the record in this case.
Thank you, Mr. Hearing Examiner. Thank you, Mr. McClure.
Okay, we have one last case in today's docket. It is Mr. Holliday's case and Mr. Samiengo. Gentlemen, are you both with us?
Good afternoon, Mr. Examiner. Ben Holliday on behalf of Silverback Operating.
Thank you, sir. Mr. Samiengo? Do you think he's muted?
Yeah, Mr. Hearing Examiner, I'm looking at the symbol next to that call in.
Thank you.
He
Thank
might
you.
be force muted.
Okay, I think
I got it.
Thank you, Freya. Mr. Samiengo, would you unmute yourself? I can hear you. Would you enter an appearance, please?
I'm here, Mr. Examiner. I just barely got unmuted. Just wow.
Would you enter an appearance, please?
John Samaniego, representing representative of American Energy Resources.
Thank you, sir. Okay, this is case number 24517. We are having a motion hearing today. Mr. Samiengo, you filed a motion to request to reopen case 24517. 24517 had been closed. There was an order issued from the division on September 19, 2024. It is order number 23405. Mr. Holliday, did I get that right?
The order was number.
I have 23405. Is that wrong?
Yes, sir. That's correct.
That is right. Okay. Issued on September 19.
Yes.
Okay. Mr. Samiengo, correct me if I'm mistaken, but you basically petitioned the division to reopen the case because you claimed that you were not notified of the original case number 24517. And therefore, since you were due notice, that is the under the rule 1915-412D, failure to provide notice is a reason to reopen the case. Am I correct?
Yes, sir.
Okay, very good. Then Then, Mr. Samiengo, Mr. Holliday filed a response to your motion to reopen. I assume you read it?
Yes.
Okay, very good. And then I provided you with a week to respond to the response. And you filed a response on the 5th of February. And you included multiple pages of documents.
Yes, sir.
Okay, very good. Okay, now, Mr. Holliday, to sum up your response, you basically are making two legal points. Number one, you were saying that the 1978, no, let me go back. You were saying that there was a quiet title suit brought in 2010 in the 5th Judicial District Court. And that court, in its findings, found that the interest owners were limited to Orion Smith Oil Properties, Ergo Energy Properties, Dusty Sanderson and Wife, DES Acquisitions, and Floyd W. Prather. These were the plaintiffs in the case, and these were the interest owners, and all other interests were quieted by that suit. Is that correct?
Yes, sir. That's correct.
Okay, good. That's correct. Okay, and even if a interest survived that quiet title suit, what you're saying is that the Champlain leases were subject to a 1978 joint operating agreement appointing Silverback the operator. So that, and then you provided an Exhibit A, which showed a footnote, and this was in an assignment bill and sale of conveyance. And that showed that the interests were conveyed subject to the operating agreement dated 7/1 of 78 between Yates Petroleum and Champlain Petroleum Company. Do I have your argument basically summed up properly?
Yes, sir. And I'll just do just the briefest of
Okay,
re-summaries.
thank you.
Our argument is twofold. Under either one of these, American Energy Resources is not entitled to notice in this case. The first is they don't own an interest because their interest was wiped out by the quiet title suit in 2010. Secondly, even if they did own an interest, those leases are subject to this JOA that appoints Silverback the operator. Those parties that are subject to the JOA are not subject to the compulsory pooling order, and therefore they're not entitled to notice or participation in that matter.
Okay. And then you included exhibits with your response, which I reviewed. And then Mr. Samaniego filed a response to the response, and in that he provided additional documents. I reviewed those. So before I begin, Mr. Samaniego, do you understand the argument against your receiving notice in case 25417? Do you understand the two arguments?
I understand. Yes. I don't, and I don't agree with them.
No, I didn't ask if you agreed because I know you don't agree. But what I'm asking you is, do you understand the assertions that Mr. Holliday is making?
I understand what he's trying to claim.
Okay, fine. So you understand those two things. Okay, then Mr. Samaniego, you filed a response, as I just said, and Mr. Holliday, have you had a chance to look at Mr. Samaniego's response to your response?
Yes, sir, I have.
Okay. What do you want to tell me? How does his response affect the case?
It doesn't. He lists the chain of title, the same chain of title that we reviewed, and that's the invalid chain of title that follows out of one of the dispossessed parties under the quiet title suit. So he's correct that those deeds are filed of record in Lee County. However, the quiet title suit and Liz Pendens were both also filed of record in Lee County, and that quiet title suit trumps this chain of title. I mean, he doesn't own an interest there.
Okay, now hold on before you continue, because I really, this is more for Mr. Samaniego's benefit than it is for mine. I've already reviewed all these documents. So, as a lawyer, I have a way of interpreting these legal documents. But so you were just saying that the quiet title suit trumps the interest that Mr. Samaniego asserts in his response. Can you be more specific and tell me which of the interests are you saying is trumped by the quiet title suit?
Sure. So American Energy Resources acquired their interest in 2018 from a party named Wildcat.
Yes.
Wildcat acquired their interest from Texona, who acquired it from Staghorn, who acquired it from Bristol Resources. Bristol Resources was one of the expressly named parties in the quiet title suit that was determined to have no interest in these leases.
Okay, so before you continue, Mr. Holliday, Mr. Samaniego, what Mr. Holliday is saying is, do you understand what he's saying?
Under the color of law, you can't go back 10 years and quiet title interests that one has already assigned to another. Those interests were already sold, conveyed, assigned 10 years prior to the quiet title. At that point in time, Staghorn, Bristol, and others that were listed in that quiet title did not own those interests anymore.
At the time of the quiet title suit, Mr. Holliday, who owned the interest that Mr. Samaniego later acquired?
Well, based on I didn't prepare the title opinion for this, but my reading of the order states would lead me to believe that the plaintiffs had a chain of title. They brought the case, asserting that their title was superior to that of the named parties, and as the order lists, any party any unknown claimant with a claim adverse to that of the plaintiffs. So my understanding is that the 5 named parties, I don't have them right in front of me, the plaintiffs in the quiet title suit were the rightful owners. We typically bring these when there is a title question, so we're involved in a lot of quiet title suits. It's to resolve issues just like this where the chain of title is unclear and the court is then asked to step in and make a determination of who owns the interest.
So, Mr. Samiengo, you acquired the interest that Wildcat had in November of 2018. Is that correct?
Correct.
Okay, good. And Wildcat acquired the interest from Texona, is it, in 2000?
Correct.
Okay. So, Mr. Samiengo, your argument is that...
Hold on. I'm pulling it up right now. I don't want to get these mixed up. Okay. Texona to Wildcat in 2000.
Mm-hmm.
And then Staghorn to Texona in 99. I mean, in 98.
Okay. So this interest, Mr. Samiengo, that you acquired originated with Bristol Resources, and that interest was conveyed multiple times before it got to you.
From Bristol to Staghorn to Texona to Wildcat to American.
Okay. And you're saying your argument, because Mr. Holliday is saying that the district court in its quiet title suit specifically had these interests in front of them and determined that they were inferior to the plaintiff's interests, and it granted the plaintiffs the quiet title suit, extinguishing all other interests. That's what I'm understanding from Mr. Holliday and from his...
The only interests that were allowed to be quiet title were those that were listed. They transferred into Texona to Wildcat in 2000. The quiet title wasn't for 10 or 11 years after the fact.
Mhm.
So I mean, therefore, the interests were not in the Wildcat interests were not quiet title because they were not listed on the quiet title.
Mr. Holliday?
Wildcat had nothing to do with that quiet title. Whatever was going on, that the interests were sold before, the whatever title search they did was incomplete, or I'm going to guess they probably didn't even do one.
Okay, Mr. Holliday?
Number one, the OCD doesn't have jurisdiction to decide these title matters. So
I
we're
know.
talking about it, but ultimately this is a district court matter. But that being said, the time for American Energy or its predecessors to have raised this was in 2010 when the suit was conducted. So they were, all the parties, all known parties would have been notified, plus they have constructive notice that's run in the county that says for multiple days, this interest is being adjudicated in this quiet title suit. And if you have a claim, you need to show up and represent your interests. They didn't, and the order was issued. And not only does the order apply to the named parties, it specifically applies to all unknown claimants in the premises adverse to the plaintiffs. So this seems to me to be a very open and shut matter.
So, Mr. Samiengo, what Mr. Holliday is explaining to you is that whoever owned the title at the time of the suit in 2010, and that'd be Wildcat, it seems to me, they had a responsibility to show up at the courthouse in the Fifth Judicial Circuit and defend their interest, and that they didn't do that, so the court extinguished it. Now, that doesn't mean that you can't bring a suit if you want to in the Fifth to try to say, hey, you know, I have a good interest here. That's not something that the division deals with. What we're dealing with here is, did Mr. Holliday and his client owe you a notice, a duty of notice to the underlying case? And what they're saying is, since this quiet title suit occurred in 2010, and Wildcat was not represented. Wildcat's interest was dissolved at that time. And that's why when you succeeded in Wildcat's interest, they didn't owe you a duty of notice. That's their first argument. So that's number one. But we also have a second argument, Mr. Samaniego. And that second argument says what, Mr. Holliday?
That the original lessee of the leases in question that we're talking about today, there's 5 of them. The original
Champlin?
lessee was Champlin. So for simplicity, just call them the Champlin leases. Those leases were committed to a joint operating agreement covering the lands at issue in the Roche pooling order, and the lands and the depths. And that Silverback has since acquired the interest of the operator. The original operator is Yates. That interest is now owned by Silverback. So Silverback was appointed the operator under the joint operating agreement. The joint operating agreement covers the lands and depths that we sought to include in the Roche order. And in fact, we only pooled, the pooling order only applies to 2.25 net mineral acres that were not originally subject to the JOA. All the other parties to that JOA were not noticed. They just participated under the JOA or will participate under the JOA.
And Mr. Holliday, but please connect the interest that AER
Sure.
claims it has, because I'm not here to determine whether or not AER still owns an interest or not. That's up to the court to decide. But connect the interest that AER claims it owns to the Champlin leases.
Correct. So at the top of this chain of title to these leases, Champlin Energy, when they committed those leases to the joint operating agreement, that commitment survives all the later conveyances. So everyone that later acquires those leases takes them subject to their being bound by that joint operating agreement, appointing what is now Silverback as the operator. And so if there were any, as I pointed out in my reply brief, if there were any doubt about it, the deed into American Energy Partner expressly states these interests are subject to the Champlin joint operating agreement. It puts them on notice of it. Again, so number one, they don't own an interest. Number two, even if they did own an interest, it's covered by the JOA. And under either scenario, they are not entitled to notice of the compulsory pooling process.
So, Mr. Samaniego, Mr. Holliday has explained to you that even if the interest that you acquired survived a quiet title suit, and that's not for me to decide, that's for the court to decide, that interest was committed in the Champlin lease.
Well, can I stop you right there?
Yes, of
I want
course.
to say something.
Go ahead.
American Energy is operating the Rio Penasco. Let me see if I got the well name here. But they're operating a well in the Champlin lease. The Rio Penasco is an operating well in the Champlin lease. I mean, American Energy has rights through and in the Champlin lease. It's operating a well in it. Not only that, but I also have documentation where EOG sold to Silverback their assets, but in book 1154, page 1016, EOG, just like in the Santos and Permian case, they only sold wellbores and kept all the interests that were assigned years prior before. So if there's any operation under the Champlin lease, it ain't through Silverback. American Energy is operating a well in and through the Champlin lease. So if Yates did assign over operation or assign over interests to Silverback, they are held by the Champlin lease that is being operated through the Rio Penasco by American.
Mr. Holliday?
Okay. Let's start with this. The Rio Penasco Working Interest Unit that was established by the Joint Operating Agreement covers the Yeso Formation. The well that Mr. Samaniego is talking about, the KD number 3, the Rio Penasco number 3, I actually looked it up this morning in response to his filing. Number one, it's outside the depths that we're talking about in this case. It's much, much deeper. I mean, this Yeso goes approximately 3,000 feet. This well, the TVD is 9,630 feet. But I'm glad Mr. Samaniego brought it up because also in the file, you can see there's at least from 2017 forward, we have 4 violations, uncured violations. And the last one was in August 2 of 24, so pretty recent. And the division stated in its notes that the well's flag is idle. Last production was reported in October of 1996, and the well needs to be plugged. So
All right.
I,
So, Mr. Samaniego, I'm not sure, it doesn't sound like even the operation of a well, it entitles you to notice, because it sounds like from Mr. Holliday's.
No, American
Can you
isn't
mute, would
compliant.
you please mute Mr. Samaniego,
Wow.
please, sir? You know, again, we show respect by allowing someone else to speak. If you can't do that, then we can't have these motion hearings. And I really want to give you the opportunity to be heard and an opportunity to protect your interests. But Mr. Holliday has gone above and beyond the call of duty to show me, as the hearing examiner, why your motion should be denied. I am denying your motion. We are not reopening the case for all the reasons that I've stated. This hearing is concluded. Thank you, Mr. Holliday. Thank you, Mr. Samaniego, and we're off the record.